Good afternoon. I'm Richie Henderson, broker with RSM, and today we are hosting a wonderful seminar on Act 278, and we hope that you're all going to get some good information here. Anyway, aloha and thank you for joining Hawaiian Realtors for an update and educational session on a new Hawaii law, Act 278, a 2-year pilot program that requires landlords to participate in mediation before filing residential eviction cases involving the non-payment of rent. And I would like to say, before introducing our guest speakers, I'd like to introduce our event sponsor. And with us today is Kahea Pistano from Allstate Insurance. And she has a $25 gift card to Amazon for a lucky winner at today's meeting. So without further ado, Kahea, take it away.
Hello, everybody. I just want to thank you guys so much for having me here today. I'm Kahea Pistano with Kuʻikahi Insurance Professionals. We're an Allstate agency. For those of you that don't know, we're right here in Hilo, across the street from Hawaiian Style Cafe. That's always the landmark I use when we're talking to people over the phone. A little bit about me. I'm born and raised on the Big Island. I've been in the customer service business for 20 years plus. I manage our Hilo office here. We are actually the only Allstate on this island. So we have an office in Hilo, we have one in Kona, and then we have a new office in Mililani as well. I'm very passionate about serving our local community. I pride myself on going above and beyond the call of duty every time to provide the best customer experience that I possibly can. My guiding principle is always to keep aloha alive. I try to live by that every day. It just reflects my commitment to treating every customer with care, respect, with as much aloha as I can. As a leader, I believe in leading by example. I'm dedicated to helping others I'm very passionate about insurance. Okay, everyone needs it. I'm very passionate about it. I know how important it is. And I also know that the average person out there will not know how important it is until something happens and you need to use it. That's when you realize, like, oh, what kind of car insurance do I have? Do I have this? What kind of home insurance do I have? And here at Allstate, we offer, I'm pretty sure you guys know, the most common auto insurance, home insurance, and then for all you landlords, we have renter's insurance. A lot of people don't even know what that is. And for $15 a month, you can have renter's insurance. I try to educate people on this as well. And it doesn't only protect their personal property, it protects them with liability as well. So I think every landlord should know what that is. And I always encourage every landlord, if you have a tenant, make them get renter's insurance. Okay, it's 2 cups of coffee that they would be spending to have a renter's policy. And everything that you get in there, it's worth it. We also offer umbrella coverage, motorcycle, canoe. We're doing a lot of canoe policies lately. And then life insurance. So pretty much do it all. As far as home insurance goes, I just want to put it out there that we do insure single wall homes, okay, because that's kind of the insurance industry. I know it's kind of going a little crazy right now. We offer insurance on single wall homes. So I know it's changing for different carriers. We also have some companies that's pulling out of the market altogether, those that have Dietrich for car insurance. Once your policy comes up for renewal, you're not going to be renewed. Like, there's a lot of things happening. So if anyone out there could use a good, local, friendly, helpful insurance agent, where you will be in good hands, I promise you, the greatest compliment for me is a referral. And anyone that is sent my way, I 100% will take care of them. Even if I can't help, or maybe if the price is a little more with me, I will recommend, like, hey, you're getting a good deal where you are. Stay where you are. It's not about making sales or all of those things. For me, it's really about helping people. And sometimes it's helping them to say, you're getting a good deal. You've been there 30 years. Just stay where you're at, but maybe tweak your coverages a little bit. So that's what I do here at Allstate. When I'm not at work, you can find me spending time with my family. I have 4 kids, in high school and then 1 in intermediate. So I'm very busy there. And when I'm not at work, I'm with my kids, and I'm also a worship leader at Connect Point Church. So that's pretty much my entire life. That's what I'm doing. I'm at work, I'm spending time with my family, or I'm doing church stuff. So if you're looking for a trusted local agent that you can trust, that has your best interest in mind, um, I am here for you guys, okay? Even if it's shopping around, looking for quotes, or if you have questions and I can point you in the right direction, reach out, okay? I will put all of my information. Um, I will be sending out my information today, and my $25 Amazon card is going to go to the first person that puts in our chat window here. What is the Allstate slogan? Somebody knows it. Come on. Yes, Josephine, Michael, you're in good hands. So, Josephine, I will be getting your email and sending you over that electronic Amazon gift card, okay? Anyone have any questions for me today? I really appreciate you guys giving me this time. No?
Maybe you
Okay.
could put your contact information in the chat. That would be helpful.
I
And
will put that in there.
great.
I have a
Thank you, Kahea.
question.
Oh, sure.
I have a question. Anything new about Lava Zones 1 and 2?
Nothing new about Lava Zone 1 and 2. I mean, we still pretty much only use HPIA. The premiums are still insane and through the roof. So nothing new, in that neck of the woods.
Thank you.
You're welcome.
Okay, any other questions? Speak now or forever hold your peace. Thank you, Kahea. I really appreciate your sponsorship of this event, and definitely I'll be reaching out to you about insurance matters. And that renter's insurance is really a good thing, and it's really kind of hard to convince owners and landlords that they should really kind of push to have that in place. Okay, moving on to our uh, panel today. Special mahalo to our guest presenters. We have Julie Mitchell, is the executive director of Kuʻikahi Mediation Center, a nonprofit community organization that provides conflict prevention and resolution services in East Hawaii. She was hired back in 2012. Also with us today is David Chee, is a Honolulu-based attorney with 30 plus years of experience, specializing in landlord-tenant law. He received his JD from the University of Hawaii at Manoa Williams S. Richardson School of Law. Also today with us is Judge M. Kanani Laubach, who was appointed in 2016 by Chief Justice Mark Reckenwall as judge of the District Family Court of the Third Circuit, Island of Hawaii. In the year 2020, Judge Laubach was assigned as Deputy Chief Judge of the Third Circuit. Welcome, Judge. And we also have with us Danielle Gella, is the Program Administrator of the Housing Assistance and Referral Programs at Catholic Charities Hawai. Serving Hawaii since 1947, Catholic Charities Hawai is a nonprofit agency providing a wide range of social services statewide. Now that introductions were made, we'll go over a little housekeeping to ensure our meeting goes smoothly. Please keep your microphones muted until you are called upon. And should you have any questions, please use the raise your hand button in the Zoom dashboard or drop your question in the chat. Okay, without further ado, I'll turn the meeting over to David. Welcome, David.
Thank you. So thanks very much for the introduction. I wanted to start off by talking about this Act 278 and what it is. And so I remember in second or third grade being told that in anything that you do, you ought to be telling people, the who, what, where, when, and why of things. And so I'm going to be using that as sort of a guideline of things. So I'm going to start off with who. And really, who this applies to is anybody who works with residential landlord-tenant relationships and anybody who has to worry about collecting the rent, or if you're a tenant, if you're worried about paying the rent. And the reason for that is because this new law is basically affecting the summary possession, which is the eviction process for non-payment of rent. In my experience, I would say that non-payment of rent makes up something like 95% of all residential eviction cases. So this is, who it applies to is anybody who's a landlord or a tenant who needs to be involved in an eviction process related to non-payment. So I did want to note that this new law doesn't affect all eviction cases. It only affects non-payment cases. So cases where you're doing an eviction because the tenant's term has expired, or you've given a 45-day termination letter on a month-to-month tenancy, or if there is some sort of bad behavior, breach of the rental agreement that is causing, you to need to evict somebody or causing an eviction case, then those types of eviction actions are not affected by the new law. The new law only affects cases involving non-payment of rent. And so that's sort of the who, that's sort of the what, where, well, the entire state of Hawaii. When it started in February 5th, the new law went into effect on February 5th. And so now we've just hit 3 weeks of it. And then the big one is why. And the short answer to why is because the legislature said so. So as a result, this is what the new law is going to be. But I think that you have to look back at the law to try to get to what the purposes of the law are. And this new Act 278 is actually based largely on Act 57. Act 57 was the law that went into effect after the pandemic, after the Governor Ige had his moratorium on evictions that lasted for like 2 years. And the concern was coming out of the pandemic and out of the moratorium was that the courts were going to get completely slammed by the large number of cases that they were anticipating that were going to happen because nobody actually had to pay their rent during the moratorium. And so they're expecting just a ton of cases to happen. And so to avoid that, the legislature put together a working group to try to come up with a plan to reduce the number of eviction cases that happened and also to help people preserve their housing. And so Act 57 came up with the program of requiring landlords, before they filed the eviction, to offer mediation to tenants. And the theory was that if landlords and tenants could talk about the case before an eviction action actually got filed, then that would reduce the number of cases that actually got filed. Additionally, if mediation occurred, then there was a greater likelihood, the theory went, that the landlord and tenant would reach an agreement of some kind that would allow the tenants to stay in their homes. And theoretically, it would mean that it was more likely for the landlord to get paid if the tenant was entering into an agreement to make the voluntary payments. And so that's what the theory was behind Act 57. And the statistics that came out of Act 57 were pretty encouraging because some huge percentage of landlords and tenants reached an agreement through mediation as to what the disposition of the landlord-tenant relationship would be. I tend to point out that of course you had a huge amount of huge percentage of agreement, because by then, tenants owed tens of thousands of dollars. Some of them, I had some that owed like $60,000, $70,000 in rent by the time the moratorium was over. So coming to an agreement was not really hard because the tenants were really they were going to get evicted. So coming up with some alternative agreement to them getting evicted was really not that difficult. Oftentimes, that resolution was a move-out date. And for the statistics purposes, if the landlord and tenant agreed to a move-out date, that was counted as a win for purposes of the mediation programs, because an agreement got made. And I'm not saying that that's not a win, because if the landlord and tenant can come to an agreement as to what's supposed to happen without actually spending all of the money and time and trouble of going to court, that's a win. I think that's a win for everybody. So in any event, that's what you're looking at, is that's the who, what, where, when, and why of what this law is. Now, of course, there's a lot more to it. So I wanted to give you some basic information regarding this new law and what it does. I'm going to contrast it with first the old law with respect to non-payment evictions. Under the old law, what was required under HRS 521-68 was that the landlord give the tenant a 5 business day notice of non-payment. And then after that 5 business day notice of non-payment was given to the tenant, after the expiration of the 5 business days, the landlord was entitled to go and file an summary possession action, assuming, of course, that the tenant didn't pay. Of course, if the tenant paid, then you wouldn't file the eviction action. But if the non-payment continued for 5 business days or more, then the landlord could at that point bring the summary possession action. Now, what is required is that the landlord has to give a very specific notice to the tenant that is no longer the 5 business day notice. If you have your 5 business day notice form that you have been using for years, because that law has been on the books for decades, you should just put that one away, because it's not going to be useful for you for the next 2 years, because at least the next 2 years, because the law has changed. You are now no longer entitled to file an eviction lawsuit if you just give a 5 business day notice. What you are required to do now is to give a 10 calendar day notice. And the form of that 10 calendar day notice takes up about 2 or 3 pages of requirement in the statute. But fortunately, the statute also said that the judiciary would publish the form of the notice for landlords to use. And so and I'm sure that
2 minutes, David.
oh, thank you. That our other speakers will tell you that this form of notice is available at the mediation centers of Hawaii. And so you can go to their website and download the form. There's a different form for each island, because each island has different information on the form for the mediation. Because what's supposed to happen is a landlord is supposed to take this form, fill it out, give it to the tenant, and at the same time upload it to the mediation centers of Hawaii to their website. And what's supposed to happen then is that in this 10 calendar day notice, the tenant has an opportunity to do one of 2 things. One is to schedule mediation with the landlord. Okay, and the other thing is the tenant could just pay off what's owed. Assuming that the tenant goes with the route of scheduling mediation, then what's supposed to happen next is that the mediation centers will contact the landlord and schedule the mediation. Under the new law, once the 10 calendar day notice is given, if the tenant does neither of those things, doesn't pay off, or does not schedule mediation, the landlord can, at the expiration of those 10 days, file a summary possession action and move forward with their eviction action. If the tenant does schedule mediation within those first 10 days, then the landlord has to wait for 20 days to expire from the date of delivery before the landlord can start up their eviction action. So it's how long you have to wait if you're the landlord before you file your eviction action depends on whether or not the tenant has scheduled mediation. It doesn't matter when the mediation is scheduled for. It might be 30 days later. But if mediation has been scheduled, then you have to wait until 20 days before you can file the eviction action. And even if the mediation is pending, you can file the eviction action at the 20-day point.
You're at 10 minutes, David.
Oh, okay. I guess I'm done.
Do you have anything quickly that you wanted to wrap it up with?
No, I think that's the main thing to know, is that the main thing to know is there. So, but I can pass it on to the next person. Thank you.
Thanks. I'm next, and we will have a Q&A at the end. So if by the time all of us are done speaking, hopefully we've answered every single one of your questions. And if not, then please feel free to put things in the chat. Okay. Can you see my slideshow? Yes. Can you see my view or the presenter's view?
Presenter view.
Okay, I've got to do that thing where I duplicate the slideshow.
Julie, you're
How's-
good.
Oh,
Julie,
I'm
you're-
good? Okay.
Yeah.
Okay. Okay. So thank you so much, David. And I'm very excited to present alongside the other presenters here regarding the pre-filing eviction mediation program, which we're calling PEMP at the mediation centers. And let me just share that while I represent Kuʻikahi Mediation Center, that serves East Hawaii, this is the same for all the mediation centers. We've all been giving the same exact PowerPoint to our different constituencies. So what I'm saying applies no matter where you have landlords or property managers or owners. It just depends which center you'll file at. I'll talk about that in a little bit. So as David just mentioned, once the landlord wants to file for eviction, they've got to provide that 10-day notice and send it to the community mediation center where the renter lives. We've had a lot of confusion so far of people submitting it, like all of their notices to us, for example, when 5 of their units are in West Hawaii and only 2 are in East Hawaii. So it's important that you file where the renter lives, where each renter lives. So when the notice is provided to the tenants, you're going to try to get it to the right center by going to the mediationcentersofhawaii.org website. And sorry, I was going to start when I started talking, so I'm timing myself. And you'll have a selection on there. It'll say, is it Kauai Economic Opportunity? Is it Maui Mediation Services? Is it Mediation Centers of the Pacific serving Oahu? Is it West Hawaii Mediation Center? Is it Kuʻikahi Mediation Center? So you pick that there. And then you're also going to submit an intake form at the same time. And you will receive back from the website an automatic notice that we have received it. And then once you're supposed to simultaneously give the notice to the tenant at the same time you're giving it to us. It's considered, I guess, served if you've hand delivered it or posted it, and it's 2 days from the postmark if you put it in the mail. So please make sure that you have everything on that notice correct. We need to have the names, the emails, the contact information, the mailing address of each tenant who is living in the unit so that we can reach out to them. And we also need to know if you're an owner and you're not going to participate in the mediation, instead your property manager is, or you're going to appear alongside your attorney, that you have those people listed on the form so that we include everybody in our communications and that everybody gets the information they need to mediate. If anyone in your grouping needs any kind of tech support, is not an English language speaker, needs an interpreter, they can request that in that intake. And also you need to do, let's say you're a property manager and you have 10 units. You can't submit one notice and one intake for all 10. You've got to upload 10 intakes and 10 notices for each unit. Then when the tenant receives the notice of eviction, they have 10 days to reach out to us and schedule the mediation session, which is free. It's free to everyone involved. And if we have not been able to get a hold of them, or if they've declined mediation, after 10 days, the landlord is free to proceed with the eviction. So when the tenant gets the notice, they should try to call us right away. You should encourage them to call us and reach out. We can also provide them with interpretation if they need it. We need to understand when they actually got the notice and also give us the times that they can do so. We're generally mediating during regular business hours. If somebody needs some kind of a different kind of accommodation, we can, sometimes we'll do things in the evening or on the weekends, but we found most people can do it during the week. And if folks are not able to do Zoom, most of these are on Zoom, we can provide assistance to enable them to participate that way. And then once the date has been set, we will let everyone know, here's your date, here's your time to mediate, here's your Zoom link. So once it is scheduled, we hope everybody is receiving our information. We tell people, add Mediation Center to the specific, or add our Mediation Center to your, contacts. So sometimes things go into the junk mailbox, especially from, if they have attachments or whatnot. And if for some reason that the tenant does a no-show at the scheduled mediation, like they were expected to be there, then the landlord also may move forward with eviction at that point. So as I mentioned, this is going to be done on Zoom. People can do it on their smartphone. They can do a laptop, desktop. It doesn't matter to us. iPad. They just need to have microphone, camera, and internet access. If they don't have that, at every center we have rooms and offices where they could use our equipment if needed. And if for some reason it really needs to be in person due to some specific circumstances, we absolutely can have it be in person as well. So what do you need to do if you're going to be coming to mediation? This is true for these kinds of mediations and others too. You want to come together prepared. You want to have your documents in order. Do you have the lease agreement? Do you have a record of how much was paid and how much is owed? Is your bookkeeping in order? If the tenant is proposing a payment plan, how realistic is that? Or if they really are not going to be able to stay, what plans do they have for moving out? Do people have attorneys? If so, do they want those attorneys to participate in mediation? They're welcome to be there in the mediation session or be available by phone as well. And thinking about what would you like to come out of this? What's your best case scenario? What's your worst case scenario? And doable. So how mediation works is we send out a confidentiality agreement for everybody to sign ahead of time. Or if they're having problems with that, people can come in and sign it in person, or if they're using our equipment, they can use it that way. We're happy to provide interpreters, including to do intakes. If people need it just to contact us and communicate with us, we can do that. We're scheduling these for 1.5 hours. So that's how long we ask you to put aside. Could be done sooner. Could take a little longer if you're making really good progress. And the way our model usually works is we start out all together as a group. The mediator does some introductory remarks and then asks each person to share a little bit about what's on the agenda for today, what they're hoping to get out of the mediation session. Then we meet with the landlord and the tenants grouping privately. And we might do that for a few times. And then we generally come back together, discuss where we are, make some negotiations. And if there's a meeting of the minds, we'll write up an agreement and we will have that for everyone to sign. If for some reason there is some compelling reason to do everything separately, like there's safety concerns or there's been like restraining orders, taken out in these cases, we could do it all separate. It just takes a lot longer because we have to keep going back and forth and it's not as efficient. If people do bring an attorney with them, they're responsible for their own fees for bringing the attorneys during that. That's the only cost you might incur. The rest of it is free of charge to the participants. So the mediators are going to ask the landlords, and the tenants a bunch of questions. So when we're talking to the tenants, we're like, hey, what led you to this place? Why are you behind? And what has changed for you that's going to enable you to be able to pay going forward? We don't want people to have pie in the sky ideas of what can they do, but maybe they lost their job, they had some outstanding medical bills, and now they just got a great paying job and they can come current as soon as they get their first paycheck. And what, if any, plan do they have to pay any outstanding rent? Are they open to some kind of a payment plan? Do they have some amazing skill that would be beneficial to the landlord? Maybe they're a house painter by trade and they'd be willing to do some kind of a work trade. Or if they're really not going to be able to stay in the unit, or maybe they're going to apply for one of the programs that Danny's going to talk about in a minute, where there's some help for tenants to get current on rent and stay current. But if they're really not able to do that, how can they create an exit strategy? And I'll just say something that, from our experience, having done the Act 57 landlord tenant mediation program after the COVID eviction moratorium, plus doing a 4-year pilot project for the foreclosure mediation subprime mortgage crisis that happened in the late 2000s. people who can leave on their own terms, it is much better all around. Their potential, like if you just agree together on a time and a date and a way that they're going to leave and how that might go, they're much less likely to trash the place when they leave, and they feel more empowered, like they decided this rather than like a sheriff having to come and put their stuff out on the curb. And also, what's their plan for leaving? When can they leave? And what can you do to help them go if that's what needs to happen? And the mediators also will ask the landlord a bunch of questions, like what's the most important thing for you? Do you really need to recoup the unit because you can't pay your mortgage unless you're getting those rental payments? Do you really need to make up the back rent, or would it be better just to have them go and you just can re-rent it right away? What was your relationship with this person prior to this? Were they a great tenant for 10 years and like suddenly they're having a hardship and you would love to keep them if you can, and you're willing to be a little bit forgiving because you know that they've been one of the best tenants you've ever had? And if they could come current, is this someone you want to keep there? Do you want to renew the lease with them if they're able to make good on what they owe? So there's a lot of different things to consider from both the landlord and the tenant side. Basically, what the mediator is there to do is help these folks to negotiate an agreement that is workable and doable for all. And mediation agreements can have a variety of terms. These are just like a very few of them. Mediation is as creative as the people who are there, and each mediation is different. But maybe there'll be a payment plan agreeing like, hey, this is how much is owed, back rent owed, and this is how many months it's going to take us to become current. And here's what's going to happen if a payment is missed. And they might, communication often breaks down when there's money owed. I think people who get into debt, they tend to go in a little bit of self-preservation mode. They might be like a turtle who've retreated into their shell, and so they might stop talking. And sometimes landlords too, we found this during Act 57, they really did not want to violate the law. They were afraid to talk to the tenant because they didn't want to do the wrong thing. And a lot of mom and pop landlords here in East Hawaii who, might not have someone like David Chee representing them, and they're not exactly sure what to do. So sometimes when we were able to bridge the gap during Act 57 and let them know that they wanted to work together, they resolved it on their own. They didn't even need to have the mediation with us. So how do we keep those lines of communication going if they're going to stay in the unit? Maybe there's a rent reduction that they're going to do in the future, or a partial work trade that's going to be worked out, or maybe there's going to be a specific move out date and they're going to waive, the last month's rent because they have empathy for the tenant, and they're even willing to be, a reference for them if they leave the place in good shape. I mean, there's all sorts of different types of agreements that people can come to. So the whole point of this is to keep people out of court and prevent eviction. It's a diversion program to do early mediation to prevent Judge Laubach, who will be speaking after me, and the other district court judges from being, they have a lot on their plates already, but it's trying to keep the court cases low and people trying alternative dispute resolution processes first before filing in court. So again, if the tenant does not attend the scheduled mediation, or they are made an agreement and they default on their agreement, then the then the landlord can move forward with eviction process. And in those two circumstances, the tenant can be asked to pay for the attorney's fees and costs incurred by the landlord to participate in mediation. So there's some recourse available. I mean, when this law was being passed in the ledge, there was all sorts of different people working on it with different interests. And so I think some of the landlords wanted to, ensure that this was not going to just prolong the eviction process, and there was going to have a little bit of a teeth into it. So I think there was some ideas to incentivize tenants to participate quickly and to participate in a realistic fashion so that that they can live up to any agreements they make. And so the mediators are really going to try to reality check them and make sure that they can afford anything that they're agreeing to. And we can't guarantee it, right? Obviously, we're mediators, we're not superhuman, but that's our job, is to try to make sure that everybody comes to an agreement that is fair, realistic, and doable. So again, I put the website in the chat. The 10-day notice is available on our website. It's also available on the court website. And those need to be submitted to our website right away concurrently with you either mailing it, hand delivering it, or posting it to the tenant. And when the tenant gets the notice, they should immediately contact us because that 10-day clock starts ticking and we want to get things scheduled timely. And although it's 10 calendar days, we only work 7 days. I mean, we only work 5 days of the week. So it doesn't even give us 2 full weeks to work on it. The 5 mediation centers in the state are listed here. And this is also on the website that I shared with you, so you don't need to have that. And then please encourage people to participate in Mediation Center. In the mediation, let your tenants know, please contact us. Please answer our calls. Please look for our emails. It's important to notify us in advance, anybody, including landlords, to notice if for some reason we need to reschedule the mediation, we can. It's really hard to get notice, less than 48 hours. And we want people to agree to things that they can live up to. So some of the benefits of mediation are listed here. It's informal. It's a lot less intimidating to go before Judge Laubach and go to court. It's the only place practically in Hawaii, other than, I guess, weddings, where people wear full suits and ties, and this is private, it's not on the record. We're trying to help people avoid having to go to court and spend the money and time and energy doing that. It's different than court in that in court, the judge is going to be the one to make a decision. They're going to rule strictly on the law. They can't enforce things like payment plans. They can only deal with, the motion for summary judgment or afterwards damages, but they can't do the same kind of agreements that we can make in mediation. The participants get to decide for themselves how to solve their own problem. And it's the last chance to try to avoid court and eviction. And also, if it's successful, it can definitely build stronger relationship and keep those lines of communication open in the future between the landlord and the tenant. So if you care to, please feel free to link to the website. And here's our QR code if you want to, if that's easier for you to go onto our website. And I believe I'm at my time. So I am going to stop my sharing. And then we are going to move on to Judge Laubach. Thank you.
All right. So aloha kako, everyone. My name is Kanani Laubach. I'm the Deputy Chief Judge for the Third Circuit of the island of Hawaii. I'm going to first send in the chat feature in Zoom 4 PDF documents. Give it time to load. It'll pop up on your screen. I want you to tap on it, download it to your device. You can use those documents. You can review them while I'm going through my PowerPoint presentation and also moving forward. So hold on while I share my screen, and we're going to discuss the judicial process. Okay. So first, I would like to mahalo Hawaii Island Realtors for organizing this webinar and for giving me the opportunity to share with you the court process as it relates to Act 278. I also want to extend mahalo to my co-presenters, Julie Mitchell, David Chee, and Danielle Gella, right? And finally, mahalo to all of you who took the time to review, register, and attend. So let's get started, right? So as the prior presenters have already spoken about, what is Act 278, right? So I've sent through the chat feature in Zoom the Governor's Message 1381. That is the actual law, right? During this presentation, you'll be able to receive and click on links, download documents, scan QR codes, and more that will help you during this meeting and going forward. So Act 278 is a law that was created to help Hawaii's residents who continue to face challenges paying their rent. I like to say it's a sequel to Act 57 that was created during the pandemic to stave off the possible tsunami of evictions when many in our community lost their jobs. As Mr. Chee stated earlier, it does modify Hawaii Revised Statute Section 521-68 as it pertains to landlords' remedies for failure by tenant to pay rent. So Mr. Chee was correct. This applies to non-payment of rent, okay? It is a 2-year statewide pilot program that provides early and free mediation for landlords and tenants before eviction proceedings for non-payment of rent are filed. So hold on, I was so busy talking, I forgot to do my PowerPoint. So don't worry, you folks will get a copy of the slides, so don't feel stress that you have to write everything down, you will get a copy of this, okay? So the program does run. It started on February 5th, 2026, and it does go through February 4th, 2028. The judiciary, as well as the mediation centers of Hawaii, we are tasked at collecting data. So at the end of the pilot program, if you folks want to know how successful it is or what the numbers are, we will have to collect the data, right? So don't worry about that. It's a pilot program. Like I said, it only applies to residential housing, not commercial leases. And the purpose, like the prior presenter said, is to encourage landlord and tenants to work out issues involving rent without court involvement. And Julie brought up a good word, diversion, right? Why I say diversion is a good word. I mean, okay, so the court is here and our job is to hear cases, right? The more cases, we only have a finite amount of judges, right? We will be getting a new Kona judge, hopefully within this year. However, there's only a finite number of us, right? If there are a lot more cases, you will have to take time waiting in court and time for your court case, right? When it finally gets set, if it goes any further than the initial appearance, right? So diversion can be an effective way, right, to reduce your time waiting in court and also attorney's fees. I think I saw Mr. Kunimura also on here. He probably doesn't want me to say this, but you know, because I always say the people that are going to benefit from this is the lawyers because they're going to get paid, right? So sorry, Mr. Chee. So, you know, diversion is good. I will tell you, it works. When it doesn't, you'll be able to file in court. All right. So how do we file in court? So the prior presenters were correct. So the judiciary, we were tasked with coming up with the mediation notice, which is available on the judiciary website. You can scan this QR code right now. It'll take you directly to that page. And it's for Third Circuit. So each circuit was tasked to create forms, fillable forms like the complaint. So if you scan this QR code, it'll take you directly to Third Circuit, right? And it's a fillable form, like I said. So there's a drop-down menu. You would just need to pick the division, right? So what is the division? Like Julie said earlier, you need to make sure that you send the notice to the mediation center in which the property is situated or located, right? So if you have a property in Ke'au, that's going to be in the Puna division. That's going to come to Kuʻikahi. If you have a property in Captain Cook, that's going to go to West Hawaii, right? I think for court purposes, if you have any question, you can ask the clerk or let them know, hey, I live in Ke'au, or hey, I live in Hilo, and they can help you decide which division you need to file in. If there's any, I guess, mistake or error regarding the division, the judge can probably catch it and then will direct you to the correct courtroom, okay? So if you want to scan this QR code, you can. Don't worry, you'll get a copy of the slides. This QR will take you directly to that website. So why I like the fillable forms is it's easy for the judge to read, right? Okay, who doesn't like a fillable form where you type things in? I'll tell you half the time. The judges, if we have to take extra time trying to make out what is written, that's really hard. And I'm pretty sure you want the judge to have all the information that's necessary and appropriate for your case without having at the court hearing to constantly ask, okay, what was written here? What was written here? So it is very user friendly and it is super efficient. So I would ask everybody, you know, download these forms to your device, to your computer, and then you can use these forms. So other forms that are available on the website, in addition to the complaint, is the mediation notice. There's also a frequently asked question page, which I did send in the chat feature, a PDF document. So those are what we believe are the frequently asked questions with the answers, and that's regarding to Act 278. Now, we also have on the website the return of service and the summons form. Now, the great thing about the judiciary recently, we also have what's called Kolo Kolo Chat, right? And it's a chat bot that can help assist the user for helping to search for any of those documents, or if you need any other information, right? So, you know, when I first learned about it, I was like, what is Kolo Kolo, right? And that is to investigate, right? To research. So you are definitely able to use the Kolo Kolo chat. And the great thing is it's even available after hours, right? So after business hours, you'll have that opportunity to use it. All right. So before I go to this last slide, I want to talk to you folks about when you fill out the complaint form, right? So you're going to fill it out, you're going to print it out. On the complaint form, when you review it, it does ask for attachments, right? So you need to look at when you're coming to court, was there a mediated agreement and the tenant didn't follow it, right? So you will need to attach that mediated agreement attached to it. And it's my understanding, and then Julie, you can correct me if I'm wrong, the mediation centers, you will be providing all parties with written documentation of when the mediation is scheduled and things like that. So those documents you'll need to attach to the complaint, right? So then the judges know, oh, wait, they have a mediation scheduled, it's coming up, right? So at least we have more information, and then it'll make your court hearing go faster and smoother, right? Okay. Another thing I also want to tell you, so say you attach the paperwork and you go to any of the courthouses, right? I will tell you, go when it's open. And because there is a filing fee, so the filing fee doesn't change, it's still $155. We ask that you don't come at 4:30 to file your document. You still can, but you're probably not going to get it back, right? Because our fiscal window that takes the money, they shut down at 4, right? So if you're going to come and file, I will tell you, come early, maybe 3 o'clock, right? At the latest 3 p.m. so that I can guarantee the filing and the payment, right? I will tell you, yes, we are open. Yes, we will take your document. We have a no bounce rule. However, in terms of the payment, it may not be able to get processed the next day. So you might have to come back the next day to get your
2 minutes, Judge.
Okay, no problem. I also want to tell you, all right, so the only thing that changed regarding summary possession is just the complaint, right? You have to use that form. Everything else regarding the service, the summons, it remains the same. During Act 57, we changed the process in terms of the return date. However, we're not changing that. The only thing that changed is the use of that new complaint, right? And that was the complaint was verified by our Supreme Court. So that is the complaint, the temporary complaint that you would have to use during this 2-year pilot program. And that started February 5th, 2026 through and including February 4th, 2028. So just make sure you have that. And then this last slide, right? Just like I said, make sure you file it in the division where the premises are located. I also put in the chat feature in Zoom our regular claims court brochure. So this actually takes you to that brochure. It wouldn't let me hyperlink it, but you have a copy in the chat feature in Zoom. And if you need any more info, that is the QR code for Mediation Centers of Hawaii. I think Julie already put it up, but it's a great website, and that's a difference too between Act 57 and now. It has the Mediation Center of Hawaii, all the mediation centers in one. And mahalo for your time. Flower for you all. Okay, thank you. And I'm going to stop my share, but thank you all for giving me this opportunity. And then I'm going to turn it to Danny with Catholic Charities so she can talk to us about the resources available in our community. Thank you, Danny.
Thank you. Last but not least, aloha, everybody. My name is Danny with Catholic Charities Hawaii, and I serve as the Program Administrator for our housing assistance programs on Hawaii Island. Today, I'll be providing an overview of the core assistance and supports offered through each of our programs, rather than just a list of eligibility criteria or allowable costs. So our goal is to ensure we are connecting each tenant with a program that best fits their unique needs. Next slide, Julie. Okay. So we currently have 3 programs: the housing and support program, our state homeless emergency grants program, and our homeless prevention program. So each collectively offer a targeted set of supports designed to stabilize tenants and reduce the financial and operational burden on landlords. A central component of these programs is rent arrears assistance, which helps tenants cover from unexpected financial crisis by covering past due balances that might otherwise lead to eviction. So this support not only keeps tenants housed, but also gives landlords with reliable reimbursement that protects them from prolonged income loss. In addition to rent arrears, these programs integrate mediation support as a proactive tool to resolve conflicts before they escalate. Mediation facilitates structured communication between tenants and landlords, enabling both parties to reach mutually agreeable solutions without legal action. This approach promotes long-term housing stability, preserves rental relationships, and reduces the emotional and financial toll disputes can create. Complementing mediation and financial assistance is comprehensive case management, which provides tenants with ongoing personalized support. Our case managers work directly with participants to identify barriers to stability. They coordinate services and create strategies that promote successful tenancy. They may assist with budgeting, employment resources, mental health referrals, or other stabilizing supports. For landlords, case management offers a direct point of contact who can help address concerns quickly and support tenants in meeting expectations. Together, these three pillars, rent assistance, rent arrears assistance, mediation services, and case management, they form a holistic structure that supports both landlords and tenants, helps reduce turnover, and promotes successful long-term housing outcomes within the community. Next slide. Okay. So landlords working with either of our programs, they benefit from a coordinated support system designed to protect their investments and reduce operational strain. So rent arrears assistance is one of the strongest incentives, ensuring landlords receive payment for pass-through rent that tenants are unable to cover. So this reduces the financial uncertainty associated with tenant non-payment and provides an immediate stabilization tool that allows landlords to continue operating confidently. Another major advantage is access to structured mediation services, which help resolve conflicts in a neutral, solution-focused environment, instead of escalating towards eviction, which can cost landlords time, legal fees, and of course, vacancy periods, right? Mediation guides both parties towards outcomes that preserve tenancy whenever possible. This approach strengthens communication and reduces conflict interactions, ultimately saving property owners money and effort. Additionally, case management services offer landlords an invaluable support channel. With designated staff assisting tenants in meeting obligations, navigating resources, and addressing personal or financial barriers, landlords gain a partner who can intervene early when issues arise. So case managers can communicate on behalf of tenants, help ensure follow-through, and coordinate additional supports that reduce the likelihood of recurring problems. So this collaboration results in more stable tenants, fewer disruptions, and a clear path to maintaining occupancy. So altogether, these benefits create a more predictable and supportive rental environment, reinforcing positive relationships and reducing turnover-related costs. Next slide. So collaboration among landlords, mediation professionals, and program providers play a critical role in ensuring the long-term success of housing placement supported by our programs here at Catholic Charities. So one of the key impacts of these programs is the reduction in eviction rates due to the combination of rent arrears assistance and early conflict resolution strategies. By addressing financial barriers directly and offering mediation as an alternative to legal intervention, the programs help maintain stable tenancies that benefit both landlords and tenants. Additionally, case management enhances program impact by offering continuity of support. Case managers track tenant progress, help resolve concerns proactively, and coordinate with landlords when challenges emerge. So this layer of communication often prevents misunderstandings and allows for timely interventions, leading to fewer lease violations and improved tenant accountability. So from a systems perspective, these programs strengthen community-wide housing stability by lowering displacement rates and supporting landlords in maintaining sustainable operations. The collaborative nature of mediation, financial assistance, and case management fosters a shared commitment to successful tenancies, demonstrating how multi-layered support can lead to meaningful, measurable outcomes. For landlords and mediators, understanding the interconnected value of these supports not only enhances engagement, but it also deepens trust in the program's ability to provide reliable, effective assistance. Last slide. So I forgot to add it on here, but I wanted to give our HELO helpline, 961-7055. I'll throw it in the chat as well. If landlords call on behalf of their tenants, please ensure they leave the tenant's details in the voicemail. We will still need to speak directly with the tenants to complete the eligibility screening. So our overall goal is to work with both the landlord and the tenant to find a solution that supports long-term housing stability, right? It's important that any plan we create also is realistic and achievable for the tenant. Because our financial assistance is intended to be a temporary resource, we aim to use it in a way that resolves the immediate housing crisis and help prevent the household from returning to the same situation or facing eviction again. So if landlords are interested in having Catholic Charities Hawaii come down to share about our resources or meet with the tenants that need assistance, we are open to that as well. So please feel free to reach out. Thank you.
Thank you, Danny. Well, this takes us over to the question and answer period. And I note, Danny, that Josephine had a question in the chat. I have a tenant that is looking for a way to get caught up with rent arrears. They reached out to Catholic Charities, but they said there wasn't any more money. Do you have anything else that can help them?
Is this for Hilo?
Josephine, can you clarify where your tenant is located?
Or which number they called?
It says Honolulu in the chat.
Says Honolulu in the chat. Okay. So Catholic Charities, Danny, I don't know if you have a branch in Honolulu. I think you're just here. You do?
Yeah. So we're statewide. So it just depends what program, but we do have funding. So if I could get a little bit more information on who you spoke with, I can follow up on that.
Okay, maybe Josephine, you can give Danny a call after the meeting and follow up with what's going on there.
Thank you.
Okay, if you have questions, you can put them in the chat or you can raise your hand and Ashley will notify me that you've done that. I have a question for Julie. And it regards to ADA accommodations for doing the mediation process. If we had to go anywhere, is that available if we had to do an in-person ADA?
Yeah, our offices are ADA accessible. There's an ADA bathroom on our floor, so we're required by our contract with the judiciary for all the mediation centers to make sure that we can accommodate folks who need
Okay,
that.
so if we had a tenant or a landlord that was in either situation and needed to have the accommodation, that is available at the mediation center. Great.
Absolutely. If people just write in, like the landlords are doing their intake or the tenants doing their intake, and if they let us know what they need, we can make sure that happens.
Okay, and then one more question for either you, Julie, or our great judge. I went to the website that you put up there, and it says free, no cost. There is no cost to landlord or tenant for the mediation services provided through the Act 278 program. I think, Julie, you mentioned that in that mediation process, or maybe it was David Chee, that you could recover costs. And I know that the standard forms lease allows for a 25% recovery of the total fees for landlord, attorney fees, and stuff like that. But anything that we do through mediation is completely free and no cost to the landlord or tenant?
Correct. So under Act 278, it's free. I mean, it's being paid through the legislature, so your tax dollars at work. So the 5 mediation centers, we collectively have a contract with the judiciary to do this work, but it's absolutely free. In terms of the monies to recoup, I think that's a better question for David.
And I'll address that quickly, which is that with respect to attorney's fees and costs for this pre-filing mediation, Act 278 specifically says that the landlord and the tenant have to bear their own attorney's fees and costs for the pre-filing mediation. The exception to that would be if, I believe that there's a couple of exceptions. One is that if the mediation agreement gets breached, and another is if the tenant doesn't show up for mediation, I believe. But generally speaking, the landlord should not be expecting to recoup their attorney's fees and costs for the pre-filing mediation.
And please clarify, the pre-filing mediation, is that the court sanctioned mediation, or is that going through the Act 278 mediation program?
It's the Act 278 mediation program. So the law basically says that after the law anticipates that by the time you get to court, the landlord will have offered mediation to the tenant, and that mediation either will have occurred or will not have occurred. But in any event, the what the law says after that is that the courts are not supposed to be sending the landlord and tenant to mediation anymore unless the court has good cause to do it. So, and there's nothing that in the law that says anything about the landlord not recouping attorney's fees and costs for mediation that the court orders after the eviction lawsuit has begun. So, with respect to the attorney's fees and costs, if it's part of the Act 278, you give the 10-day notice, the mediation center reaches out, mediation happens. That mediation there that happens at that point, you should not expect to recoup your attorney's fees and costs as a general rule. But if it's some mediation that happens outside of that scope, then I don't believe the law prohibits a recovery for attorney's fees and costs.
Okay, and I think Judge Laubach, you could probably weigh in on, you're not going to really be able to put a claim in for the recovery until you get to the damages part of your case. I mean, it's not part of the summary possession process. This would be in the damages side of it where you'd be looking for recovery.
Right. So in summary possession cases, it's two-part, right? The first part is whether or not the tenant can remain in the property, and the second part is the damages, what if any money is owed, right? So I think, I'm gonna throw this out, right? Okay. So Act 278 says once you serve the notice, it's mandatory mediation for the landlord, right? The landlord it's mandatory for the landlord to participate in mediation, right? But I don't know, Mr. Chee, if you want to talk about, right? Maybe you think about, so like, do you want to serve the notice, right? Or can you talk to the tenant? So say, maybe it's $800 or $900, right? Once you serve that notice, the law, it requires the landlord to participate in mediation. So Mr. Chee, you want to talk a little bit about that? I know I'm sorry to put you on the spot, but I think this is like amazing, a different alternative. Right.
Yeah, the thing to consider is that once, I think that under the prior law, landlords were sending out 5 business day notices for, any amount that was owed. If somebody owed $100, the landlord would send out the 5 business day notice, which would then entitle them to actually file the eviction lawsuit if they wanted to do it. But, nobody files an eviction lawsuit over $100 because you're going to be spending more than that just in your filing fees. But if you decide to give the 10 calendar day notice to a tenant over $100, and you upload that to the mediation centers, and then the mediation center schedules mediation, the law requires the landlord to participate in mediation. Now you're going to be participating in an hour-and-a-half mediation over $100. You really got to reevaluate whether or not you want to go through this process if the dollar amounts that are in question are kind of small. So I recommend to my own clients that they reevaluate, when they send out these letters. And the other thing I recommend to clients is that rather than sending out this 10 calendar day notice, uploading it to the mediation center and doing mediation, is if the amounts in question are below a certain threshold. A lot of my clients are using 1 month's rent as a threshold. But if you have a lower dollar amount or a dollar amount that you feel more comfortable with, you might want to just reach out to the tenant and ask them to come and talk to you about setting up your own payment plan. Because one of the things under the new law is that if you enter into a payment plan or some sort of settlement agreement with the tenants that's outside of mediation, and then the tenant violates it, then you don't actually have to give this 10 calendar day notice. You can go straight and file your eviction lawsuit in court. So you can bypass a large part of Act 278 if you, as the landlord, talks to the tenant and just reaches an agreement with the tenant on your own without going through this this process. Also, to address one of those questions, one of the earlier questions, if you incur attorney's fees and costs in reaching a new agreement with your tenant and it's outside of this pre-filing mediation program, there's nothing in the law that says that you can't charge those attorney's fees and costs back to the tenant. So you really want to consider, if you can, entering into agreements with your tenants outside of this program. And really, you would go into and give the 10 calendar day notice after you have failed to reach agreement with your tenant on your own. So that's something that you might want to consider. So,
Okay, thank you, David. I have a follow-up to that. So a landlord goes in and does the filing, 10-day notice for mediation, but then before the mediation session is actually scheduled for, the tenant comes in and pays the rent or whatever the amount owed was. Now, you're saying that by law, the landlord is then compelled to still go to mediation in that case.
We wouldn't still hold the mediation. If both parties told me that they've come to an agreement, we would say case settled prior to mediation and we would cancel the session. So I think there's a couple things that we've noticed is like property managers with large units, for example, that they tend to have the same people be late every month. And they said, are we going to have to do a mediation, a 10-day notice for every single one of these every month? And I think what David just spoke about might be a good way to handle those. For other tenants who, you know, you're having a hard time talking or coming to an agreement with, mediation is a really good way to proceed. But if you folks have worked it out before the scheduled mediation session, we're not going to compel you to mediate nothing if there's nothing to mediate. You know, so you've given it you've filed, you've done everything you can, but if you've come to an agreement prior to the scheduled session, we will cancel it. We just really ask for 48 hours notice because it's a lot of work on our side to get these scheduled and have the mediators ready. And, you know, they're trying to get you all, you know, the Zoom link and get you to sign the mediation confidentiality agreement and whatnot. So we want to make sure that we're using our time efficiently over here. But we are here to help. I mean, the mediators are trained to help people communicate to each other. You do not have to bring an attorney to mediation. Some people want to, some people don't. Property managers can do this on their own. Owners can do this on their own. You know, sometimes it's in partnership with an attorney. It just depends where you want to be on it. And I feel like Danny's services and what she has available. I'm going to share with you folks a resource list for Hawaii Island of the various programs that are available and that with a specific phone number to call. So if you can get connected up with her services and, you know, that might help your tenants out if you want to keep them, that would be also really helpful. And starting those conversations early is good because all the nonprofit centers like Catholic Charities, they're inundated with people needing help. They want to help, but they can't do it immediately. So the sooner that you can get them connected with those services, the better for you, the better for the tenants.
Great. Thank you, Julie. I know time-wise, we're like 6 minutes over the 1-hour session. And I just wanted to ask Faith that did you get the question answered regarding the cost of mediation? If so, that's great. If not, call me or call Julie or they can give you further information on that. Okay, if there's no further questions, this concludes our educational session. The session was recorded and reflects information accurate as of today. For current resources, visit mediationcentersofhawaii.org, and that website was provided, or check with your local mediation center. So for those on Oahu, I recommend you logging into that website and the information is there. On behalf of Hawaii Island Realtors, mahalo for attending and a special mahalo to our guest speakers for taking the time to come and explain to us what's going on. Julie, David, Judge Laubach, and Danny, have a great day, everyone. Thank you very much.
Aloha.